Hey there, I'm estate planning attorney Paul Rabalais, and if you're one of those married people, like so many other married people who engage in estate planning and leave a trust for their spouse as part of their estate plan, you're going to want to make sure you watch this video from start to finish. It's all about who will be the trustee of that trust you leave for your spouse. All right, so lots of married people, lots of married couples are out there setting up revocable living trusts as a way to leave things for their spouse, to their other heirs when their spouse dies. They're setting up last wills and testaments. Married couples are each doing their own will. And often in those documents, whether it's a living trust or whether it's a will, married people often provide something like, when I pass away, I leave my estate, or I leave the remainder of my estate after any specific distributions were mentioned. I leave my estate in a trust for my spouse, and if my spouse needs some of those trust assets for their health, education, maintenance, or support, distributions can be made from that trust to my spouse for those purposes. And then when my spouse later dies, the trust assets will revert to my remainder beneficiaries. So that's really, really common. But you've got some decisions to make when you leave a trust for your spouse from your estate, whether it's from your estate or from your living trust. All right, here's your options on who should be the trustee of that trust for your spouse. Option number one is your spouse. Yes, you leave your estate to a trust for your spouse, and you even say that the trustee can make distributions to your spouse for their health, education, maintenance, or support. And when you name your spouse as the trustee of that trust, yes, your spouse can make distributions to themselves under this duty to be reasonable to preserve the trust assets for the remainder beneficiaries. But quite frankly, your spouse can make distributions to themselves if you name your spouse as the trustee of the trust for your spouse. Quite frankly, that's common. So when you do that, even though we're talking about trusts here, no pun intended, you're trusting your spouse to do what's right after you pass away. So naming your spouse as the trustee of a trust for your spouse is common. Option number two, name someone other than your spouse as the trustee of the trust for your spouse. You pass away, you leave your estate, it's $1 million in a trust for your spouse, and you say when your spouse dies, it goes to your 3 children, for example. Well, maybe you designate one of those 3 children as the trustee of the trust to your spouse. Now your spouse, your surviving spouse, after you pass away, can't make distributions to themselves out of that trust. Your surviving spouse would have to rely on that other person who's the trustee to make distributions to your spouse. So can be a little wishy-washy there. So again, be careful if you name someone other than your spouse as the trustee of the trust for your spouse. Third option, name co-trustees of the trust for your spouse. Maybe you say, you know what, I'd like my spouse and one of my children to be the co-trustees of the trust I leave for my spouse when I pass away. Typically when you name 2 co-trustees, and the trust instrument really dictates this, or the applicable trust law dictates this, but typically when there's 2 co-trustees, it takes both co-trustees to act or to make a distribution to your surviving spouse for their needs. So a lot of people like that kind of checks and balances. Yes, you want your spouse to be involved, but you also don't want them to have that free rein to take distributions. You want another co-trustee involved. Or you might name 3 or more co-trustees. And can a majority act? Well, it depends on the terms of the trust instrument, and it could depend on the applicable trust code if the trust instrument doesn't address it. So, but typically when you have 3 or more co-trustees, a majority can act as a trustee. And a final option is to name a corporate trustee. It's where you say, you know what, I don't want my spouse to be the trustee. That's just not appropriate. I don't want individuals other than my spouse to be the trustee. I'll let this corporate trustee, this corporate bank trust department, or this trust company, I'll name this trust company as the trustee of my trust. So when I pass away, The trust company will govern everything, they'll manage everything, and they'll determine if and when it's appropriate for distributions to be made to my spouse after I pass away for my spouse's health, education, maintenance, or support. So there you have it. Now, the right trustee, this is an important decision because the right trustee who communicates well, who takes their job serious, it really can enable those relationships of your survivors to thrive. Select the wrong trustee or co-trustee, you may be looking at a knockdown drag-out that really severs relationships for decades or even for generations to come. So really important decision. Hope that helps. Make sure you like, make sure you hit the subscribe. I'm currently making a push for that 100,000 subscriber count. At the time I'm making this video, I'm a little over 97,000. Help me get there. Mention it in the comments below. We'll see you next time.